Jeff, I would love to know if I can bring a negligence claim against the state of Florida.
Yeah, that's a great question, and one that I frequently encounter in my practice. I'll have clients who are injured in a number of different ways. Sometimes they're in an auto accident, and that accident can be caused by road construction that's being done in the area, or it could be caused by an employee of the state of Florida driving around in a car. And really, the law, the answer is yes, you can bring a negligence claim against the state or the agency, the government agency that caused the incident. For example, um, Hillsborough County Sheriff's Office, City of Tampa, Florida Department of Transportation, the Hillsborough County School Board or school board of whatever county you're in, if your child's injured at school as a result of the negligence of a public school teacher. So any of those situations where somebody who's working not just for the state of Florida, but for a governmental agency, you can bring a claim against that governmental agency. Now, typically you cannot sue the actual employee himself or herself for the incident. But if they were acting in the scope of their employment with the government agency at the time that they injured you, then you would have a claim against the agency. Now, unfortunately, those claims are handled a lot differently than claims brought against individuals who are not part of the state. And there's a Florida statute that's directly on point. It's Chapter 768.28. And that statute governs claims against the state or its agencies. So it's very important that you hire a lawyer who is familiar with that statute and has brought claims against government agencies in the past, because it can be like a quagmire and a puzzle to put together to figure out exactly what you need to do in order to preserve your claim. For example, you have to give notice to the appropriate state agency and typically also the Department of Financial Services up in Tallahassee. And you have to let that notice sit for 6 months while they investigate and decide how they're going to handle the claim. And you cannot even file a lawsuit until that notice is given and that 6 month time period expires. So, I would highly encourage you to contact a lawyer. The good news when you're hiring a personal injury lawyer for a claim like this, the good news for the injured party is that the attorney's fees are limited to 25%. A lawyer cannot charge more than a 25% fee when you make a claim against a government agency. The downside for the injured party is that the claims are capped, meaning that you can only recover up to a certain amount for your injuries. In Florida, that cap is $200,000 per person and $300,000 per accident. What does that mean? That means that if you are hurt badly enough, and you have a claim that's worth $1 million, you typically can only recover $200,000, regardless of how badly you were hurt. And if there were 5 people in the car, or 4 people, or 10 people in the car who were also hurt, the maximum amount that the government agency has to pay out is $300,000. So if there's 5 injured people, there's only going to be $300,000 to be split amongst the 5 injured people. There are some very limited exceptions where you can apply for what's known as a claims bill and try to get the Florida legislature to allow you to recover more than the cap. But that is a very difficult and long process to go through, and it's often unsuccessful. So the bottom line, after hearing all this, I hope you realize, is that it's critical that you hire a personal injury attorney who has experience in these types of claims before you move forward.